All right, this is case number 21-241121. This is She Long versus William J. Johnson. The matter is before on a petition for installment payments. It looks like. Let's see what's on here. All right, let me. Do I have Long? She say something if you're here.
Your Honor, good morning, Your Honor.
Morning. All right. William Johnson. Do I have William Johnson here?
Yes, Your Honor.
All right. Good morning to you, Mr. Johnson. I'm looking.
Morning, Your Honor.
Looking at the register of action that was generated in this case. There was a motion for installment. The motion was denied, and then a hearing has been set up today on a petition to show cause. Wherein the plaintiff seeks to enforce judgment. All right, talk to me, Mr. Long. What's going on here, sir?
Your Honor, this case was started, and I was awarded the amount of the money which the judge indicated. Since that matter, this case has been prolonged, and mistakes have been made by the court. And finally, we went and served a subpoena to Mr. Johnson. After that, we had a Zoom conference call for him to answer for the subpoena, but apparently he never showed up. And the judge in the matter and the clerk of the court indicated to me after we served the subpoena, when we had a Zoom hearing, they told him to wait because Mr. Johnson has not arrived, and what they were going to do is issue a bench warrant. But apparently we waited. Sorry.
What happened? Yeah, I understand the history here. What happened is that he didn't show up on the subpoena, and they issued a show cause. But he's here today. Why didn't you show up when the subpoena was issued previously, Mr. Johnson?
The last are you referring to the court date when I was served?
Yeah. The last date that you were supposed to be here, there was a subpoena issued that ordered that you appear in court some time ago, and you missed that.
Yeah.
Explanation as to why you missed that date, sir.
If it was an early morning court date, the only thing I can think of, I work nights. I'm sorry, I work nights, and I get off like 6 in the morning, sometimes 7 in the morning. So that might have been an issue with my sleeping, and I'm not using an excuse. And
that's not an excuse.
That's not an excuse.
That'll get you locked up in jail. Let's get to the bottom of this. Looks like there was a judgment that was entered that's in the nature of $3,000 or so, and the plaintiff wants to collect on the judgment. He wants to get paid. I saw that you filed for partial payments before, and looks like it was granted on one occasion and denied on other occasions. It looks like you're not paying. What are you going to do on this?
I was trying to set up motion payments for installments, and I was trying to get something set up because I couldn't pay the whole balance in full. And I was trying to get something set up like, I'm sorry.
Yeah, but it looks like when you set up something before that you didn't keep the agreement.
No. Whatever I set up, I believe that he filed like he objected or something like that. He put in paperwork to stop my motion for payment installments, because I was told that that it was denied. My motion for payments installments was denied because I was trying to get something like something monthly set up, like $100 or $150 a month or something. So, if possible.
All right, I do see what the magistrate did deny your petition. Well, let me ask you, sir. How much do you earn annually, sir?
Weekly or yearly?
Annually, how much do you earn? A year?
A year, I would say around 48,000. 40 to 48,000.
You said about 48,000 or so. You have any kids?
No, sir.
All right, are you married?
No, sir.
You own a home?
I rent.
All right, how much is your rent?
Rent is
Your
900.
Honor, correct, Your Honor. He's living
I
with
didn't
his
ask you anything,
parents.
Mr. Law. Mr. Law, did I ask you anything yet? I don't think so. How much, sir?
Rent is currently 900, but the landlord did give us a notice that they would possibly be going up.
All right, possibly increase. Okay, what other obligations are you paying at this time?
Just on my car note and
How much is
insurance.
your car note?
On my car note is currently $565 a month.
Do you pay insurance on that car?
Yes, I do.
All right, how much is your insurance?
Roughly around $180 a month.
A month? All right, got you. All right, any other expenses that you can, that stand out to you in terms of what you pay on a monthly basis?
Besides my phone bill, I got my phone bill I pay, groceries, pretty much gas, to get back and forth, get around.
How far do you work away from where you live?
About good 8 miles, 9 miles,
About 8 miles, you said?
about 8 to 9 miles.
8 or 9 miles. All right. So your take-home pay weekly or bi-weekly, whichever way you get paid, what do you usually bring home?
Well, regular weekly is about take home about 600 to 650.
All right. You have some other, and that's every week, correct?
Every week.
All right, gotcha. All right. Mr. Long, strike that, just before I come to Mr. Long, Mr. Johnson, what are you asking to pay, sir?
Sorry, sir.
I'm asking if I could pay like, if possible, no more than like 200 a month or so to get it all squared up.
All right, thank you, sir. Mr. Long, what do you have to say, sir?
Your Honor, if you look at the case, Your Honor, it's been going on since 12/29/21. Now, this defendant, firstly, number one, he does not rent. He lives with his parents. Yeah, at the house when we served the subpoena, we saw he was living with his parents, with his mother and his brother. He's not renting the place. The house belongs to the mother. Now, secondly, Your Honor, this motion for his installment was denied. It's been more than 1 year, Your Honor, I've been trying. We've tried every motion possible. Every time we try to do a motion, it's been misdirected. Mr. Johnson had ample time, that's 1 year, Your Honor, to make the payments up, or even what he indicated, he could have saved that up by now. He has no intentions of paying, as he indicated in front of the subpoena officer, that he has relatives who are in the court system or the whatever. Every time I've tried every motion possible, Your Honor, I've been misdirected, misled. My files have been lost. I have been very patient. Every time I come to the court, Your Honor, I have to pay fees. Every time, you see, when the judge indicated me the amount of my payments award, they left one thing behind. They didn't tell the defendant he has 14 days to pay. So what happened that day, Your Honor? I took my car in to get it fixed.
Okay, I don't want to hear about that. Okay, I've heard enough. Thank you. Thank you. I don't want to hear about that. You got a judgment and you have the right to enforce that judgment. Under the law, if a judgment against you or anybody else, they have the right to petition the court for an order of partial payments. A part of the reason here that there hasn't been any payments is because you've objected to those payments every time that they've come up. You've intercepted the defendant's willingness to offer something by way of payment. And if you refuse that, then obviously you're not going to get any pay through any voluntary mechanism, because I know what you like is you like to have the opportunity to enforce the judgment without there being an order of partial payment. The defendant has indicated to the court that he has other obligations, but he also has this obligation. So the court is going to fashion an order that requires that he pay under a partial payment order. You can enforce through other mechanisms because the order for partial payment will simply prevent the assignment of a wage assignment as it relates to his job. But it would not prevent if you decide that you still want to do enforcement actions against bank accounts or anything along those lines. So the court, after listening to the testimony offered or the statements offered regarding the finished resources, the court would find that he has the right under statute to make partial payments on this judgment. I'll set those payments at $250 a month. I'm going to order that that first payment be made on this matter by the, because this has been it's been a little while going. I'm going to go ahead and set that payment up that has to be made by the 2nd of December, 12/2/22. I will assess $100 cost as a result of the the failure to make one of the hearings in this matter. And so that first payment that you make, sir, is going to be $350. You've got to pay that on the 2nd of December, 2022. And then every month thereafter, on or about the 2nd of the month, you will be required to pay $250 until the judgment is paid in full. The $100 does not go towards decreasing the balance. The $100 that I assess is cost. And that is the court's determination. I will issue orders, and orders will be sent to both of you as a result of the hearing today. Okay, to both of you, and I do wish you well. The court now calls case number 22-177-803. This is C-Spine Orthopedics versus City of Detroit. The matter is before the court, set on for review. I have recently received the orthopedics witness list and a few other items. Your appearance at this time for C-Spine.
Good morning, Your Honor. Christina Abro, P78224, here on behalf of C-Spine.
All right, good morning to you, counsel. And for the City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P85118.
Thank you, Mr. Patterson, and good morning to you as well, sir. I had this noted as a case set for review. So, I don't recall the specific issues that were raised at one point. So somebody update me, please.
Yes, Judge, we have actually resolved this matter. It resolved last night, so we are settled, and we should have closing documents to the court as soon as we get those finalized.
All right, Mr. Patterson?
Yes, that's right. So we've settled yesterday. I'm waiting on some information from plaintiff. We'll get paperwork submitted and get dismissal to the court in the coming weeks.
Does this require city council approval?
It does not. It's small enough it does not. So it's just a matter of the paperwork and getting the check cut. So 2 to 3 weeks.
So I have an order that if it's okay with both of you, I'll go ahead and issue an order conditionally dismissing it, and that dismissal becoming a dismissal with prejudice upon the transmittal of the settlement funds in this matter. That makes sense to both sides?
That's fine with me, Your Honor. So when the settlement funds are sent, it's automatically dismissed with prejudice. Is that my understanding?
And
that's fine with me.
That's fine with us, Judge.
It would also provide for automatic reinstatement if something goes wrong. So I'll get that out to you today, and you should get it in the next few days. If anything goes wrong, you'll see the nature of the order. It will just tell you that you can automatically reinstate it, or that it turns into a dismissal with prejudice once the funds are negotiated. All right, good day to the two of you.
Thank you, Judge. Have a good day.
Thank you, Your Honor.
The court now calls case number 22-1879-84. This is Coleman Tyson Case Management LLC versus USA Underwriters and Michigan Automobile Insurance Placement Facility. The matter is before the court. I think this is set on as a pretrial hearing in this matter. Your appearance for plaintiff regarding this matter, please.
Good morning, Your Honor. Gregory Young on behalf of the plaintiff, P40125.
Thank you, Mr. Young. Good morning to you, sir. And for defendants, USA Underwriters and or Michigan Automobile, somebody go right ahead.
Good morning, Judge Chad Dushinsky, P number 81872 for defendant USA Underwriters.
All right, thank you, counsel. Good morning to you, sir. Is there someone representing Michigan Automobile Insurance Placement Facility, or are you on that?
No, they've been, we stepped to dismiss them, Your Honor.
All right, very well. All right, got it. I thought I saw something in here along those lines. Just make sure. Very well.
And if I may, I might be able to short circuit this for you a little bit, Your Honor. There is the principal plaintiff patient apparently has a case, excuse me, in Wayne County Circuit. We are obviously secondary to them by assignment. It looks like if I'm overstepping my bounds, Chad, let me know. But Chad and I, the defense counsel and I spoke this morning. It looks like the defendant is filing a motion for SD based on misrepresentation under the policy in Wayne. I suggest, Your Honor, since we are, secondary to that plaintiff, the primary plaintiff, that if we put this over for maybe 120 days, because if they get dismissed there, then it's pretty clear what we have to do.
Your Honor, that's correct. And we did just take the patient's and insurance deposition, so I can file that motion for SD within the next week or so and hopefully have an outcome that's going to dictate the outcome in this suit within the next 2 months, hopefully.
Exactly.
My only concern here is that, is this going to take 120 days out? Because I've already got you on the scheduling order here. We spent a little time, and essentially I'd like to bring it back sooner than that. So how are they scheduling things over there? Are you getting it in, you think about maybe within the next 60 days or so?
I believe Judge McCarthy usually sets out SD hearings within 60 days, not a super quick turnaround, but we'll hopefully get a ruling by then.
All right, so let me put it out there. I'll bring it back in. Let me bring it back in late February. Of course, calendar just shifted over. Just want to take a look and see where things are at that time. So I'm going to go ahead now and set your date, and that's going to be February 23rd. February 23rd, 2023. 2/23/23. And that's going to be at 9:45 a.m.
So February 23rd, 23 at 9:45.
9:45 a.m. You will get another notice on this. Court does find good cause for adjournment of the pretrial, and the matter is reset for the date is set forth on this record.
Perfect.
I wish you well, gentlemen. We'll see you on the other side, and happy holidays to you.
Happy holidays to you, Judge, and I'll talk to you later, Chad.
All right, sounds good. Thanks.
Thank you.
Court now calls case number 22-190291. This is Bank of America versus Melvin Walker. The matter is before the court, set for a general hearing. I believe this may be the first hearing regarding this matter. Your appearance at this time for the plaintiff.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722. How are you today?
I'm good. Good morning to you, sir. Let me have Mr. Malcolm Walker, if you're on the Zoom, say something at this time. Mr. Walker, I see a name indicated there. If you are on the Zoom, Mr. Walker, please say something at this time. Looks like you're on mute. *6 should get you off of mute, sir. Looking for Mr. Malcolm Walker. Have you spoken with Mr. Walker this morning, counsel?
I did, Your Honor. He was at work and he messaged me in the chat and said he was having an issue. He might have to step away. We do have a resolution. I told him that if it came to that, I would just ask the court for some time. I'm going to send him some documents and we'll get him into the court. We have a settlement in place and we're going to be dismissing conditionally. I'll send him the paperwork. We'll get it back and I'll have it filed with the court.
All right. So let me go ahead and give you where you can send those, at least by way of email.
Sure.
That's at Carmen, C-A-R-M-E-N, Carmen.Banks, Banks is the last name, at 36, it's 368, 36districtcourt.org.
Okay.
Right. So I'll note the file that the matter has been resolved and that we're waiting paperwork. So we close this out.
Perfect,
Right,
Judge. Thank you.
Good day.
Take care.
The court now calls case number 22-1121. This is Modern Financial Services Corporation versus Dwayne McClendon. The matter is before the court. The court having received an answer to the complaint. There's also been the submission of a pretrial matter as well. Your appearance for Modern Financial, please.
Good morning, Your Honor. J. Latif Beg, B-A-I-G, P36820, appearing on behalf of plaintiff and the attorney of record.
Thank you, Mr. Bay, and good morning to you, sir. I'm looking now for Dwayne McClendon. If you're on the Zoom, Mr. McClendon, say something at this time, please.
Yes, I'm here, Judge. Good morning.
Good morning to you, sir. I see, of course, that this is a case alleging damages at $5,754 as a result of an automobile retail installment contract. It looks like this may very well be the first hearing in front of this court regarding this matter. Now, has there been any conversation, any talk about trying to get this resolved? I did receive the defendant's answer to the complaint. Any discussions thus far, counsel?
No, not with me, Your Honor. I really don't have settlement authority today. What I'm looking to get is a scheduling order with your standard scheduling order with maybe 60 to 90 days of discovery.
All right, Mr. McClendon, tell me where you want this case to go. What are you trying to do regarding this matter?
I'm really trying to honestly get my money back from this car because simple fact I've been having trouble with this car. I've only taken it to Legends Motors. I had a warranty that they never used. They were supposed to replace the engine in the car. They did not. I sent you pictures and they told me it was replaced. The engine started knocking like a week after I got the car out the shop. And
so let me stop you for a moment. So you purchased a warranty, you paid extra money to purchase a warranty.
Additional warranty onto my car note.
All right. And so with the car, you purchased a car, did the agreement call for you purchasing the car as is? And then you purchased a warranty separate from that? Is that what happened?
Correct.
All right. All right, very well. So what I'm going to do is I will set it up for the parties to engage in what's called discovery. That is the process of the parties exchanging information and raising whatever issues they wish to raise during that period of time. So I'm going to put it on a 60-day discovery order. This is a normal part of the process. That's going to bring this case back in front of me the of January. That's going to be January 18, 23, and that's going to be at 9:30 a.m. That will be a pretrial conference. Now, in the interim, both sides have the right to request documents of the other side. And whatever documents they intend to use at trial, whatever documents they may have regarding this transaction, if you put something in writing requesting those documents, then the other side is required to turn that over to you. Also, either party can issue what's called interrogatories. Interrogatories are a set of questions that have to be answered under oath. And either party can submit that. And if they're submitted, they have to be answered within the time required by law. There's also items called requests to admit. It's where a document is drawn up and says, do you admit that such and such happened? And those items have to be answered. And if they're not answered in the time allowed by law, they become statements that are admitted, even though there was no answer given. So you have to answer those things within the time permitted by law. And after that process has taken its course, I will review the matter. And that's what that January 18th, 2023 at 9:30 time is all about. In the next few days, you'll get an order from me in the mail. It will have that date on it. It will also have the right to conduct discovery, as I've just talked about. It will also have the right to file motions. That will be in paragraph number 6. So both parties will receive that in the mail in the next few days. So until January 18, 2023, anticipate receiving the scheduling order, and I'll see you back at that time. The best of the holiday season to both of you. Good day to you, Attorney.
You too, Your Honor. Thank you.
Your Honor,
Case is over, sir. I've already ruled in your case.
Your
Are you
Honor,
still
but with great respect to you, Your Honor, the motion of his installment payments, that was denied 2 times. Apparently,
I don't care that it was. It doesn't matter that it was denied 2 times. Sir, in 99% of the cases where there is a judgment against someone, there is the right or opportunity to pay by way of partial payment. The partial payment just has to be a fair amount. Everybody wants all of their money right away, but the law allows for a person to file a petition and to ask for a partial payment. The fact that the magistrate.
I understand that, but Your Honor, the fact
So
is.
you want to talk now.
Your
You
Honor,
want to hold up
please.
the whole court and talk. So go ahead and talk. You go ahead and take up everybody else's time now.
Excuse me, Your Honor, I've been waiting 1.5, nearly 2 years for this, Your Honor. The matter of the fact is,
Maybe you should have accepted. Okay, we both can't talk. We both can't talk, and I don't want to waste time with it. Look, you could have, during that year, you could have filed garnishments against bank account. You could have filed a garnishment against his wages.
we did that, Your Honor, but my paperwork is
Don't bring that here. Don't.
I've done everything possible, Your Honor.
It sounds like to me, that you want to talk and not listen. So you don't need to be here right now. Thank you. All right, this is case number 22-193-236. This is Credit Acceptance Corporation versus Mary Letitia Whitley. And the matter is before the court. Following of a general civil complaint, the court has received an answer to the same. The matter is joined and set on for a scheduling conference on today's date. Your appearance at this time for the plaintiff.
Thank you, Judge. May I please report Richard Gruson, my bar number 35222. I'm the attorney of record for the plaintiff, and I'm the attorney of record for the plaintiff today to tell you that I have the case settled.
All right, thank you. Good morning to you, Mr. Gruson. Let me see if I have Ms. Whitley here, or are you telling me that? Okay, let me see. I see someone. Is it Whitley? Or did you settle it before reaching here, counsel?
Yes, Judge. May I please court? Just perfect the record. I like to listen before I like to talk. So,
Yeah.
I can tell you that after 4 o'clock, I have a signed and sealed settlement order from opposing counsel Nick Balberman. So therefore, I am prepared to this afternoon hand file that with the clerk's office, because I was intending to travel to the clerk's office this afternoon for other sundry legal filing.
All right, very well. on those representations, counsel, then I would deem that the matter has in fact been resolved, and we will await the submission of the proper order on this regard. Thank you, sir.
Thank you, Judge. Have a great holiday.
Likewise to you, sir. All right, this is case number 21-240898. This is Michelle Maxwell versus Dunyan Detroit Realtor. The matter is before the court. Looks like set on for a pretrial conference on today's date. Just one moment. All right, so that there was a motion to set aside an order that was issued, I believe, in the small claims division of this court, and to have the matter set on the court's schedule. The court then did issue a scheduling order setting today's date as a pretrial conference date. Your appearance for, first of all, let me see if do I have Michelle Maxwell, please?
Yes, sir.
All right, good morning to you, Ms. Maxwell.
Good morning, Your Honor.
Do I have counsel for Dunyan Detroit Realtor? Your appearance
Yes.
at this time.
Good morning, Your Honor. Rania Haddad, P84927 on behalf of Dunyan Detroit.
All right, and good morning to you as well, counsel. So I know that the order judgment, I believe, was set aside in this matter. Set this up for a pretrial. Has the parties looked towards setting up any way that they might be able to get this resolved, Madam Counsel?
Well, Your Honor, we did file an answer and a counter complaint. We filed that in October. I think it was around October 14th or 15th, Your Honor. The plaintiff has not, Ms. Maxwell has not filed an answer to it. So we're actually just asking for a final pretrial date. We'll be filing an MSD motion.
Just one moment. Maxwell,
Yes.
of course, your complaint is yet pending before the court, but you do know that there has been a counterclaim that has been filed against you.
No, I didn't.
Okay, so it looks like this document was submitted to the court, that a summons was issued regarding this matter, and it indicates that it was filed. Looks like I have the stamp November 10th. So, Madam Counsel, has this been sent to Ms. Maxwell yet? She says she hasn't received it.
Yes, Your Honor, we did send it to her. She was served with the copy of the document.
No, I haven't received anything else from you all since the last court date when I spoke with the other attorney.
So you live on Russell Street, you still live there, ma'am?
No,
Oh,
my mail is held at the post office, and I just checked the post office. I've been checking the post office every day. I haven't received anything.
let me ask you this. So if someone sends something to the address on Russell, it would be held at the post office? I guess what I'm saying is that the address that they're using is the Russell Street address. Is it appropriate or correct for them to mail it to the Russell Street address, or should they be sending it somewhere else?
They can send it there. I'll get it at the post office. Yes.
Okay, that's what I was getting at. So.
Yes,
the,
yes, my mail is held there. They haven't sent anything, Your Honor.
Okay. All right, so they're gonna need to get this to you. You're gonna need to file an answer to it so that the other side does not get a default judgment on that counterclaim. Because the counterclaim is suing, alleging damages of $12,250. So you want to
Your Honor.
respond.
Okay, because Your Honor, this is just another tactic from another court case that we had with them and that I had encountered.
It may be, and your complaint might
So,
be attacked too. Your
okay.
complaint might be attacked, their complaint might be attacked, I don't know, all right?
Oh,
That's
okay,
what-
I mean, that's
that's what-
fine, Your Honor,
that's-
because.
Are you listening? You listening?
Mhm.
That's why we have court. Otherwise,
Okay.
we just get our guns and bow and arrows out. That's why we have.
That's
court.
fine.
As we go along. Okay, so Madam Council, if you could oversee making sure that this document is sent out to Ms. Maxwell. I know that you've indicated that it's been sent, but obviously it's a pretty important document. And so I'm going to direct that it be mailed out again regarding this matter.
So just for the record, Your Honor, we are mailing it to the Russell Street address again.
That's what I wanted to clear up and make sure that that was the case. And the plaintiff says that that's the correct place to send it. So that, go ahead and do that. Then we'll address these issues as we go along. All right, so I did give a scheduling order. I believe that that scheduling order allowed for some discovery, or am I getting this mixed up with another file?
No, it did allow for some discovery, Your Honor.
All right, very well. So what else has to be done? I know that the answer to the complaint, is there anything that requires immediate attention from the court before this matter gets settled?
Yes, Your Honor, I just wanted to ask the question. This case started back in September of 2021. I followed everything to the T of giving them all the notices of all the attempts to collect and whatnot. Even with coming to the court dates, they did not come to any of the court dates, and they tried to say that they did not know of any of the court dates, but they did, because I was in.
Your Honor, I would just object to this.
Excuse me.
Statement, because we did file a motion to set aside.
Excuse me.
Stop. Yes, you got a default judgment. They filed a motion. That motion, are you listening to me now?
Mm-hmm.
That motion set that default aside. Just like today, they filed a counterclaim against you allegedly back in October. And if they were asking for a default today because you haven't answered that, perhaps they could get a default. Then what you would do is file a motion saying, Judge, that default should be set aside because I didn't receive notice. And guess what would probably happen? That default would get set aside because you would honestly come before the court and say, Judge, I didn't get the notice on that. That's what happened with the other case. You did what you were supposed to do and you got the default. And then the other side came and they said, Judge, we missed something. It's not necessarily her fault. We missed it, but we want an opportunity to come to court and have this case heard on the merits. That's all this is. That's where this is now. Now they found something you got. It's the same procedure. And so that's why the judgment was set aside, is because there was a motion that was filed. That motion made certain allegations saying that they were not properly notified, et cetera, et cetera. The favor in the state of Michigan favors cases being heard on the merit. So if a party can show good cause as to why the judgment should be set aside and show that they have a meritorious defense to the claim, then there's a reasonable basis that the default will be set aside. That would apply also if a default was entered against you on this counter complaint. If you file something and say, I didn't get it, Judge, they're just stalling this complaint that they brought before me, it has no merit to it, I have a defense to it, then I'm a likely set it aside and say, okay, let me hear the bottom line. So that's what this case is now, is that, there's a complaint, counter complaint. At some point, I'm going to have to hear both sides of that, weigh it out, and determine what the outcome of this case is going to be. That's what procedurally, that's what this case is right now.
Okay, because I just was asking, Your Honor, because of the simple fact that everything was done in a timely manner of doing it, and then it seems like that after everything was done, then they came back and wanted to do this default. If everything would have went, because I was supposed to get a bailiff back in August, if everything would have went like a bailiff would have worked, then
Let me
therefore
stop
I
you
wouldn't
now.
have been there.
Let me stop. Let me stop. I have other cases. I try to explain to you the process.
I understand what you said. That's
No,
fine.
listen very carefully. I understand. I wanted you to understand the process. The other thing I want you to understand is that as we keep on talking about what happened back then, this case ain't gonna never go forward. I don't have time to talk about that anymore. I explained that to you. I think you understand what occurred there. There's nothing else to talk about. If something may have went right, some things may have went wrong. Everything may have been beautiful, but the case has moved on from there. We're in a different space with this case now. That's why when even counsel spoke up, Ms. Haddish objecting and all, I don't want to hear it just yet. This case is going forward now. The default is set aside. This case is lined up for the next step. I don't want to hear all that other stuff. You're talking in the past. We're trying to get to the future with this. All right. So I will set a date, a final pretrial conference date, and I'm going to set that about 45 days out to bring it back, because I want to take a look at this case and see where this case is in terms of progression. So I'm going to go ahead and set it for the 11th of January, January 11, 2023, 1/11/23 at 9:45 a.m. 1/11/23, 9:45 a.m. The answer should be done to the counter complaint by that time, and any other issues that the parties wish to raise, challenges can be done by that time. And then I'll take a look at where the case is in terms of setting it for trial, or if there is a likelihood of being able to resolve. So 1/11/23 at 9:45 a.m. You get a notice from me regarding that date in the next few days. All right, good day to both of you. I wish you well.
Okay, you said January the 11th, right?
Yes,
At
ma'am.
9:45. Okay.
And you'll get a written notice regarding the date as well.
Okay, I just wanted to make sure. Okay, thank you, Your Honor.
Good day to you. Good day,
Thank you.
Madam Counsel.
Bye-bye.
All right, this is case number 21-61958. This is SC Company Incorporated versus Mr. Corned Beef, also known as Mr. Corned Beef. The matter is before the court on the filing of a petition for a set-off, and also on, looks like, a petition or motion to vacate balance of a judgment entered. And I thought I also saw a motion to vacate, strike that. Just wanted to make sure we got everything that we should be. Just one moment. All right, your appearance for plaintiff, SC Company Incorporated, please.
Good morning, Your Honor. This is John Mueller appearing on behalf of SC Company.
All right, Mr. Mueller, go ahead and put your P number on the record, if you will, sir.
P35413.
Thank you, Mr. Mueller. Good morning to you, sir. Your appearance for defendant, Mr. Corned Beef Group, please.
Yes, Your Honor. Gregory Reed, that's P24750 for Mr. Corned Beef.
All right. Thank you, Mr. Reed, and good morning to you as well, sir. I recall that I dealt with this case on one occasion way in the past, sitting in for Judge Nance Adams. I thought she was gone, and then she came back for a brief time, but now she's gone for real to brighter places, I believe, in the state of Tennessee somewhere. My understanding is that an order was issued post or after the time that I got involved in this case. And the motion that I saw, Mr. Reed, is that you were asking the court for a set off or an offset because there apparently is another case that has a judgment and more money is owed to your client than is owed under the other judgment, something along those lines. So talk to me about that. But before you do that, Mr. Mueller, was there some petition to to set aside Judge Nance's order or something, or? Tell me
Yes,
what's
Your Honor,
tell me what's going on with this matter, I guess.
There's apparently two separate cases, and I think you might have called the 21 case, but I think this is the 20 case we're on here today. And that's part of the confusion.
Okay, hold on one second. Yeah, and now you're reminding, thank you, you're reminding me of some stuff. My intent was to have both matters in front of me today. But this is the 20 case. Now let me go to Mr. Reed. I'll come back to you, Mr. Buell. Mr. Reed, it is in the 20 case that you're raising the issue regarding a set off. Is that correct, sir?
Yes, Your Honor. To bring you up to date, that case has been paid in full by the client. They paid $19,000 some to SC Company. That was collected, the final payment. I was trying to get that done before this court date occurred. So,
Okay,
so the set off is,
yeah, so that when you say that 19,000 has been paid, is that in this 20 case or in the other case?
that's in the 20 case.
Okay, so I have the 20 case. I have the 20 case in front of me. So you're saying that there has been a complete payoff in the 20 case. That case is resolved.
That is correct. But the client has overpaid SC Company by $150. That was an overpayment made yesterday. The 16th, that is.
So that's when this was paid off, November 16th, and the client overpaid by 150. That's what you're saying.
That is correct. So all the set off that I was asking for earlier has the matter has become moot now because the case was not called before then. So,
right, got it. Yeah, I tried to get it in front of me as quickly as possible because I saw the emergency nature of the motion, but that issue is moot. So where do we go from,
well, first of all, there's an overpayment, so we need to get that back.
All right.
And so my the $150. And so go ahead.
I'm glad it's not 3 more zeros or something.
That's in the 20 case 161958. So we request that to have that back. And so the related case that is before you as well is 21-167-920. So I would ask, so then we have to deal with that case now, because we have a request for a judgment. The default was entered, and also the court had refused to set it aside as well twice.
Your Honor, if I may.
What's your business in this? Give me an appearance or something.
Yeah, so I'm here on behalf of SC Company in the 21 case. And for the record, Ahmed Berry on behalf of SC Company, and for the record, 84541. And today, Your Honor, we have the motion to set aside the default that was entered on October 5th. So that's what we're here for in the 21 case.
Yeah, and Judge Nance Adams passed upon that, did she not? And she denied the motion to set aside. Is that correct?
Yes.
No, there's two judges. Judge Johnson refused to set it aside.
Okay.
And Judge Nance entered the default.
Got it.
And then today's motions for reconsideration, Your Honor.
Mr. Berry, you're next. I'm coming to you. I want to hear you.
Oh, sorry.
What else? Were you saying something else, Mr. Reed? I haven't forgotten you, Mr. Buell.
Okay.
Thank you, Your Honor. Judge Nance entered the default, and then Judge Johnson sat in and reviewed the file, and she refused to set aside that default that was entered by Judge Nance. During that time, during that interim period of time, you had ordered the party to bring $10,000 to the court. They would refuse, and they ignored your order or your request.
That's not true.
That's my order, I'll come to you, Mr. Barry. No,
You
the
know,
court ordered that money.
You ordered that, but they refused to sign. They refused to sign the order that I had submitted to them on them. And so the day that you have before you is a motion of reconsideration of the two judgments that the default that was entered.
All right, Mr. Barry?
Yes, Your Honor. So on June 16, Your Honor, you ordered that Sobel PLC and David Sobel are non-parties to the case, and also ordered an escrow account. And then we filed a motion for partial reconsideration onto the escrow account. And Judge Adams ordered that the partial reconsideration is denied, but we just because the case is moot, that we are non-parties, therefore we don't have to put into the escrow the $10,000. So that's why the 10,000 was not entered. And on that day, the only thing was up was the escrow and the parties, the non-parties not being a party to the case. And then they just entered a default against SE Company out of no motion to enter the default was before the court. Nothing was before the court about the default, and judge entered the default. Then we filed a motion to set it aside, and then judge denied the motion to set it aside. And then we're here today on the motion for reconsideration based on the default only. The escrow was ordered that we don't have to put it into escrow because we are non-parties.
No,
That's really not what the court ordered. The court ordered the party that received the money out of escrow to put the money back into escrow. That's what I ordered.
that is
I
correct.
don't order non-parties to do stuff. That's not what I did. I ordered the party that had received the funds out of escrow to put the money into escrow with the court. That's what I ordered. Somebody's playing a little bit of Mickey Mouse, but it's clear to me what I ordered. And I think that's some of the confusion that comes up when people, when cases are bouncing around between judges. But no, I didn't order an escrow agent to do anything. I ordered whoever took the money or whoever got the money to place the money in escrow with the court, so that it would be under the court's control. That's what was ordered by this court. All right, so I do have from the plaintiff's response to the defendant's ex parte motion to vacate balance and so on and so forth. That's still in the 20. That's just one moment. Yeah. Okay, so the other case is a 20 case, or is that a 21 case?
A 21 case.
Both are 20 cases.
No, one is 20 and one is 21.
Okay, I'm trying to get some information on the 21 case, because that's the one where there is a motion to set aside the default that was entered by the court in that matter, and for reconsideration of Judge Johnson's determination in that regard. So while she's getting that, I mean, Mr. Berry, when you say that that the court sua sponte entered a order of default, or that it was entered administratively or something, what's the best that you could tell me on that? I haven't looked at anything yet.
Your Honor, from what I understand, there was a motion to enter the default against SD sometime in the history of the case, and that was denied. And we went, so so then we went into the motion for partial reconsideration on the escrow account. And it was ordered that we didn't have, SC didn't have to put the money to the escrow, but just entered the default against SC company anyways. But the default was not like, there was no issue of default before the court at that time. And then we went in front of Judge Hinnett, I believe, for the set it aside, and then she denied it. And then this is a motion for reconsideration right now, Your Honor.
All right, Mr. Bueller, what's going on, sir?
So, if I could, Judge, so
Your sound's a little bit distorted. You're the only one that
sorry,
can.
I'll try to get closer. It's a little confusing because I also filed a special appearance in the 21 case, but I don't know that it needs to be dealt with. But let me get back to the 20 case quickly. I just didn't want to interrupt Mr. Reed at the time, but I don't agree with his assessment. I show that I'm still owed $1,254.29 on my judgment on the 20 case. I don't show a $150 overpayment. I would suspect, but Mr. Reed will have to confirm this with his client, that some of the confusion could come from the bailiff fees. I mean, I only get so much after the bailiff collects the payments. So if they're adding up the gross amount that they're paying the bailiff, I don't receive that, of course. The bailiff gets his statutory fee. Each of the payments are coming through a court bailiff. This is on the 20 case, from a properly issued order to seize property. He went out there. He's the one been collecting the payments in lieu of closing down their store. We let them make payments. I show there's one more payment, just for the record, of $1,254.29 is my balance. I don't show a $150 overpayment.
And what you're saying, Mr. Mueller, is that could be bailiff fees that occurred along the way in these collection efforts, correct?
That's correct, but that's only my guess. I've seen that happen so many times before, but I don't know that to be the case. I'm just submitting that. All I know is I still have a balance. Remember, interest continues to accumulate over all this time. Maybe they're not accounting for that.
No, yes, Your Honor. Based on the installment agreement that was entered by the parties since February the 15th, 22nd, each the client has made payments and entered and actually made the final payment on the 16th based upon that agreement. There was no other additional costs or fees. They paid off per the installment agreement. And that was submitted in full on the 16th of this week.
So the installment agreement did not have a separate bill of cost or agreement regarding paying any cost to the bailiff or anything along those lines?
The installment agreement, I'm looking at it in my hand right now, the statutory service and mileage fees and all the other costs that were agreed to. So it was built in.
All right.
And they paid it out.
Your Honor, I'm sorry.
Go ahead, Mr. Miller.
My quick reply to that is, I think we're mixing up terms. There is no installment agreement per se.
Mr. Miller, your sound is distorted. I'm barely able to hear. It sounds muzzled.
I'm gonna try something else here. I wonder if I lost power on something. All right, I'm not sure what else I can do. I'm using the same thing I always do. I'll try to speak louder. I'm not aware of an installment agreement per se. All that happened was I issued an order to seize property, and they've been paying on it to the bailiff. This is just all post-judgment. There's no installment agreement. Now, what I'm assuming Mr. Reed is referring to is the bailiff came to me in the beginning and said, if they could pay X amount a month, would you forestall from seizing property? And I said, yes, it was a reasonable, the payments, but that didn't stop judgment interest or anything. We didn't have a so-called installment agreement. We're just collecting on a judgment, and I allowed them to make payments in lieu of me closing them down. There's no agreement to waive judgment interest or anything. I think that's what Mr. Reed's referring to.
Block tickets. Is that the installment agreement that you're talking about, Mr. Reed? That the forestalling of it taking any enforcement actions, so long as payments are made pursuant to the agreement?
Yeah, what I'm referring to is the payment and inventory of seized property. And there was an agreement based upon payment per each month. And the parties has complied with the terms of that agreement that they had signed with the bailiff.
Oh.
Yes.
Well, Mr. Mueller, that it sounds like somebody missed something, or that sounds like an agreement to resolve it in a certain manner. And if that agreement is paid off, that would be the end of this.
Well, except that I'm not a party to that agreement, so I guess I have to see it. I don't know what it is. If you look, there's an order to seize property, and I'm not going to tell the bailiff to go in there and start seizing things at this late date, but he's supposed to collect the whole balance for me, just like any post judgment. I'm like I say, I'm assuming. I guess I'll have to see it, but my only assumption could be that he did tell them, as long as they continue to make payments, and pay this off in full, that he wouldn't seize property, and they have been making those payments. So I haven't done anything else. I'm just waiting for the final payment. Then I'll file a satisfaction of judgment. So I'm not sure what they're calling an agreement. It isn't with me.
Well, this party had signed it, and this is what they had agreed to, and they have paid it in full.
Okay. Maybe he'll have to submit that, Judge. And maybe the court will have to make a ruling, but I can only surmise that it goes back to the earlier agreement where I said, okay, I won't close you down. I won't take all your stuff out as long as you make X amount of monthly payments until paid in full. And that's where we're at. Now we're almost done. There's never been any objection or any reason to question it until now.
All right. It certainly, well, I'll take a look at, which I don't have in front of me. I wish I had all that stuff down. But I'll take a look at what that agreement is. I mean, obviously, when you got, third parties and what have you involved, or you got ancillary persons involved, bailiffs and so on and so forth, the alignment of agreements sometimes can be a little confounding. But at the same time, if a party relies upon the document where there is forbearance and there is a set amount that will satisfy the outcome, then they should be able to rely upon that, and that should put the case to rest. That's what it sounds like to me.
Well, we'll have to see it, I guess. But what he's saying is, listen, I haven't seen it, so it wasn't my agreement, and I don't know how they get out of the statutory interest in any court costs, which I'm assuming is the difference. But maybe Mr. Reed could submit that to me. I'd be happy to take a look at it.
Your Honor, I'd be glad to, but I had never heard of anything else that someone said they're going to tack on something when there was an agreement to pay it in full, and based upon an installment arrangement.
Gentlemen, I mean, really, Mr. Reed's been around a long time. Mr. Mueller's been around a long time, and both of you have been in front of me multiple times. This is kind of like a little bit different. I mean, if you've got something in writing and there's a document that says you pay this and it's paid off, this is the end of it.
That's not. I believe me, Judge, I understand what you're saying, but we did not have an installment agreement. That's why I say I have to see it. This is not something I signed. This is not something we bargained for. So I'm just guessing here. Somebody have to submit it to me, I guess.
My determination on that issue is that it seems to me, based upon what the court has heard, is that a document was generated as a result of action to enforce judgment. The document that was generated was beneficial to the defendants in that it allowed them to be free from further enforcement actions so long as they paid the agreement. A secondary item that occurred as it relates to the document that was drawn up is that it set forth the amount that had to be paid in order to complete the agreement that again was beneficial to the defendant because they didn't have to worry about enforcement action so long as they were keeping the agreement. And maybe by way of misdirection or mistake or whatever it was, there was an understanding in a written document that certain amounts were to be paid at certain times and in a certain total amount. And when that total amount was paid, that would constitute the satisfaction or that would constitute the payments that were required under this case. The defendant has completed that that based upon that document. And that would seem to me that it has resolved the case. So that my determination would be that the defendant would be entitled to a satisfaction of judgment unless plaintiff can show other reasons or some basis by way of motion and by way of accounting that something other than that agreement should apply in this matter. So my determination is that the defendant is entitled to a satisfaction of judgment regarding that matter. And if that is true, then if the defendant has overpaid regarding the agreement, then the defendant would be entitled to a refund of the overpayment based upon the agreement. Again, that will require accounting. But if it's $10,000 and the defendant paid $10,150, that he has 150 back. And that I'll sign an order consistent with what I've just indicated on this one.
Well, Judge, that motion is not up today. I've never seen it. He brought some kind of motion for set. The defendant brought some kind of motion for set off, if I understand it, brought this up for the first time today. I've never seen this agreement. I didn't make that written agreement. I'm not on it, so I don't know how to even respond.
And that's why, Mr. Mueller, you do have some breathing room. As I indicated, if there is something other than what Mr. Reed has set forth, then it's almost in the nature of showing cause or providing something to the court different than the document that Mr. Reed and his client relied upon in an effort to satisfy the requirements of the judgment. So if you've got something different than that, or something that shows that is not a complete statement of the agreement or the arrangement for satisfying the judgment, then I'll entertain that. I'll be glad to take a look at that.
But I don't have what he has, is what I'm saying. I can't respond to it. I don't have it.
All right, Mr. Reed. So, Mr. Reed, you will need to get that to Mr. Mueller right away. If you could email it, get it out to Mr. Mueller right away. And if anything is filed, I'll set a hearing and I'll go forward. I'll revisit it on a motion for rehearing on this issue.
Yes, you.
All right,
I'd be glad to, Your Honor.
As it relates to the offset, Mr. Reed indicated that that's a new issue, that's already been resolved, except as it relates to the $150. That's the issue that remains. So the order should say that the court has made the determination as set forth on this record that there is a $150 that is due back, and that that Mr. Mueller has the right within the next 21 days to assert that there is something applicable other than what Mr. Reed has relied upon as the quote unquote agreement in this matter.
Thank you, Your Honor.
All right, Judge, thank you.
All right, thank you, Mr. Mueller. All right, I do have in front of me the 21 file 21-167-920, Mr. Cornby versus SC Company Incorporated, and I have a long diary of what has occurred here, and I'm just taking a quick look, and I do see that
With the court's permission, I'll leave then, Judge, okay?
all right, thank you, Mr. Miller. Good seeing you, sir. Happy holidays to you.
Thank you, same to you.
Well, I see multiple entries in the space between July and October of this year. And many of them address issues relative to a motion for summary disposition or partial summary disposition. And then I start seeing a motion to set aside a default. And maybe I missed it somewhere, but I don't see where the entry of default occurred.
It was August the 3rd was the first default that was entered by Judge Nance Adams. And then October, motion to set aside the default was entered, that was denied. And then also,
when I'm looking at 8/3/22, I'm seeing a plaintiff supplemental response to defendant's motion for summary disposition, defendant's counter response summary. Let's see, motion for partial consideration. Motion is moot. Motion for summary disposition, thinking out loud. And I see now where a default was entered, non-compliance with pretrial scheduling order deadline. Default entry.
that is correct.
Did not appear for motion hearing. Order assigned to Judge Nance. So she entered the default because defendant did not appear or did not comply with the pretrial scheduling order. Actually,
That is correct.
All right. And then Judge Pennant Johnson denied the motion to set that aside. All right.
That's
So
correct.
counsel, you got Judge Nance entered it, Judge Pennant Johnson refused to set it aside. What's the gravamen upon which it should be reconsidered in at this point, sir?
So Your Honor, the whole issue is that Sobel and Sobel PLC really don't represent SE Company. We were, so if you look at the case caption, it's SE Company, FKA Broadway Corned Beef Inc., and John Doe's agents and attorneys. So to avoid any default or anything against SE Company's attorneys, which would be us, we filed on behalf of ourselves. And then there was a big misunderstanding as to if we represent SE Company or not. So that's why the defaults were entered. I mean, the failure to comply with the scheduling order, they weren't served correctly for the scheduling order. They weren't served with a notice of hearing for the August 3rd. We appeared on behalf of ourselves because we're non-parties, and we just had to reserve our rights for this case because Counsel Reed named John Doe's and attorneys, so we had to reserve our right.
Your Honor, that is
You did not appear on behalf of SC?
No, Your Honor. We appeared on behalf of Sobel.
So,
could I comment, Your Honor?
yeah, in just a moment, sir. I just want to see.
Sure.
So in this matter, it looks like is SC Company the only defendant in this matter, Mr. Reed?
Yes, Your Honor. And you got all these.
Go ahead, sir.
And you have all those pleadings been filed alleging that this non-party was not a part of it. But if you check the file, which is what Judge Johnson did, there are pleadings indicating that that Sobel PLC entered appearance for SC Company. That's why Judge Johnson refused to set aside that default because they have filed pleadings on behalf of SC Company. So they can't be wearing two hats playing a shell game and trying to throw the courts off and saying they are non-parties. And they have filed all these frivolous pleadings saying non-parties. Then they also had represented SC Company at times.
Mr. Berry, is there anything in here that's going to show that your office?
Your Honor, there in the file there are. Sorry.
Is there anything in this file that's going to show that your company, your firm represented SC Company?
Your Honor, there are two pleadings to where it says, and by mistake, but it says that defendants now come defendants buying through their attorney Sobel PLC, and that I guess it was a mistake on behalf of whoever drafted the pleadings, but throughout the whole.
All right, I'm sorry. I'm sorry for the loud noise, Mr. Mr. Berry. You know, it's almost getting to be something that borders on an ethical kind of problem. You know, if the judge determined that SC that comply with the schedule of the court, and there is indication that, first of all, SC then is in default, and any notion that an appearance mistakenly from your office indicated that they were representing somebody, and especially on more than one occasion, I don't know. I don't think that's the argument that you're making. I hope it's not. I hope you're not making that argument.
No, Your Honor. My argument as to the default is the default, the motion to enter the default was denied before. And at the August 3rd hearing, there was no the hearing was for the partial reconsideration considering the escrow, and then just a default just got entered. That's my argument, that the motion to enter default was denied before.
But it sounds to me that the judge sua sponte determined that there had not been compliance by SC and therefore entered a default. That's what it sounds like occurred there. So, I mean, I don't get it, and I don't see a basis to set that default aside. I don't. And then this business about maybe they weren't represented or something. I don't think you even want to get into that kind of discussion. That's, you know, that hinges on some almost like ethical kind of stuff. Just like the whatever occurred. I won't even back up to that because it's not even necessary in this case. But I ordered, and my order was very specific. I wish I had drafted the order myself, because when I ordered the money placed in escrow, whoever received the $10,000 was required to put the money in escrow. Whoever received it was required to put the money in escrow. And the notion that somehow that was a moot point, and that the court didn't have authority to do that. The $10,000 was the subject of the dispute. But that's what happens sometimes when cases get thrown between judges. But it's almost an unethical kind of argument for someone to make the argument that somehow the court is ordering the escrow agent to put $10,000 into escrow. That's not what I ordered. I ordered the party that received the $10,000 to put it into escrow. That's what I ordered. And to argue something different to that because there's a different judge, that's unethical and improper. But in any event, as relates to this is your motion to set aside the default entered in that matter, that motion will be denied. I don't see a basis to set that aside whatsoever. All right, so get the appropriate orders to be I'm running between corporals, otherwise I draft them up myself. That's why I do that all the time. But I'll get the appropriate orders to me. I think my orders are real clear on this record. If you're not clear about what it is, then order the record. And let's not monkey around with it, trying to figure out another way of presenting something differently than what the court has ordered. Right? All right, that's my determination in this matter. All right,
Yeah.
good day to both sides.
Yeah, Your Honor, but there was another matter that has been pending before on that file. It was the request for the judgment entry, and that was on October the 14th, I believe it's on the Register of Actions.
Given that the motion has been denied, you may submit your order, your order of judgment. The motion to set aside the default has been denied. You may submit a proper order of judgment. I believe that the complaint was for some certain. Is that correct, sir?
That is correct, Your Honor, and that has been filed as well already.
You've submitted an order already?
It have been submitted according to.
All right, let me see that big file again. All right.
Yeah, I don't. For the record, I don't have a copy of that order.
October the 14th was some certain that was on the Register of Action. October 14th.
Yeah, I'm seeing your application that sounds in $16,125. Is that correct, Mr. Reed?
Yes, it is.
All right, then 10,000 is the damages in this case, and you've asserted actual attorney fees as a part of this judgment. Is that correct?
That is correct, Your Honor, and that was also based upon the complaint itself. Because this complaint was based on conversion of the $10,000, which entitled the parties even for trouble damages by statute.
Yeah, but you're not seeking trouble damages in the order, correct?
No, I'm not.
But you are seeking actual attorney fees, correct?
That is correct, Your Honor.
All right, so counsel, what I'm going to do is I will take the I'll take the order for entry under advisement, and counsel, I'm going to treat it as a 7-day order, although I'm going to make it a 14-day order. So I'm going to give you 14 days to file whatever you may like to file in relationship to objections to entry of the order that has been offered in this matter. So, Mr. Reed, counsel said that he has not received a copy of this. So once again, you're going to need to get, it's been filed with the court. You're going to need to get a copy of that to Mr. Berry right away. And you or your clients will have the opportunity within the next 14 days to file an objection to the order. I'll consider it as like a 7-day order, but you have 14 days to object to the order. And if there are no objections after 14 days, the order will be entered. If there is objection, then the court will set a hearing on the objections. All right. And so that I'm going to go ahead and set it up. I'm going to go ahead and mark off the 14 days, if you will. So we are, as you know, we're at the 17th, so that order has to be, or you have to file an objection on it before December 1st.
December 1st, Your Honor?
Yeah, on it before December 1st.
And Mr. Reed, if you can email it to me, just because mailing is very slow.
Yes, I'd be glad to. Yeah, I'd be glad to, Mr. Berry.
And for the record, Your Honor, for today's order, it is only concerning the motion to set aside the default. Is that correct? Which would be denied.
I believe that that's the principal issue that was raised here, and the court has made its ruling on the motion for reconsideration of setting aside the default. That motion is denied, and the court has accepted the proposed order of judgment and is allowing 14 days period for objection on it before the 1st of Listen.
Thank you.
Yeah,
Have a nice day.
thank you. We're set, Your Honor.
We're all set. All right, good day, gentlemen.
All right, thank you as well.
This is case number, all right, case number 22-179-262, American Express National Bank versus Deborah Lewis. The matter is before the court on the filing of a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. John Whitty appearing on behalf of the plaintiff. Correct.
Thank you, Mr. Whitty. Would have been good to get this one in front, this one before the last one.
Well,
And
yes.
One interesting case turned into two interesting cases at one time. So, all right. So I'm looking now for Miss.
Judge, we're actually resolved. I emailed and faxed over a consent judgment. I mailed it to yesterday. So we have a consent judgment that the court should have. So I'm just withdrawing our motion and we're resolved. So.
All right, sounds good. So did you email it to the email address I gave you today?
I did. I just did after I heard you say it, but I'm not sure if it was at Carmen, CARMEN .bank.
Yes.
Yep, I did about 30 minutes ago, Your Honor.
Okay, sounds good. We'll get that all taken care of and get it back to you, sir. All right,
Okay.
thank you. I'll note file accordingly.
Thank you, Judge.
Good day to you.
Have a good day.
Deborah, I gotta go around to the next spot.
Boy, oh boy, we haven't had one like that in a while.
It was a little roly poly. It was just